Hello and welcome to the Estate Planning Introduction. I'm Brian Qualls and I'm really excited to get to meet you here. The purpose of this video is to provide you with an idea about what estate planning actually is, give you an overview of the process, a breakdown of the important documents involved, and how to get started. Just a little bit about me. I am an attorney. I've been practicing exclusively in this area for the last 15 years, and I've helped close to 1,000 clients with exactly the kind of thing that we're going to be talking about throughout the duration of this video. Before we go any further, I want to just back up for a moment and reflect a little bit about why you're here in the first place. I don't know you, but I'm pretty sure there's a lot of things that you could be doing today. And I've got a lot of respect for the fact that you're sitting here watching this information right now. So I just want you to take a moment and reflect on why you're here in the first place. We don't do estate planning for our own benefit. Yes, you'll experience peace of mind as a result of having this in place, and that's great. But at the end of the day, we do this because we care an awful lot about the people in our life. So think about who those people are, because that's going to be your motivation. So hold on to that. Here's what we're going to cover today. We're going to talk first about what estate planning is. I'm going to give you an overview of the process involved, a discussion of the 4 key estate planning documents, and then last but not least, a discussion of next steps. What is estate planning? Fundamentally, estate planning involves 3 different components. Number 1, or rule 1, if you will, is while I'm alive and well, I want to remain in control. If you sat down and met with an attorney or some other professional and they started spinning off all of these ideas about things that you could do, and you started to feel like you were losing control, you probably wouldn't be comfortable with that. So, rule number 1 is, as long as you're able to be in control, you should remain in control. Everything can be changed by you. All of the details can be revised, revoked. Anything that you want, you can always do, just the same as you can right now, today. That's rule number 1. Rule number 2 is to provide for you and your loved ones if you become incapacitated. This is one of those things that we don't often think about. We usually, when people are thinking about estate planning, they just skip right ahead to what's going to happen when they die. But before that, we need to think about, what if you couldn't do all of the things that you can do here today? What if you couldn't sign your name? What if you couldn't think clearly? What if you couldn't pay your bills? Life just doesn't stop if you're not able to do the things that you can do today. So proper estate planning makes sure that people in your life that you trust are able to act on your behalf and do all of the things that you do right now during any period of time that you were unable to do it because of a mental or physical incapacity. Rule number 3 is, when I die, I want to give what I have to who I want, when I want, and how I want, with as little expense, tax, inconvenience as possible. I like to think of this as a process that we go through. It starts with education. That's what we're doing here right now, is giving you an idea about what's involved, what the tools are, so that you begin to get more comfortable with your understanding of all of this. Then there's the design. If you're working with a qualified estate planning attorney, you will put forth a proper amount of energy into the design of your estate plan. With my firm, that starts with an online interview form that has been developed to make the initial steps in the process as convenient and easy as it can possibly be, followed by the necessary consulting so that you are able to get your questions answered and have the necessary human element and the necessary advice so that you're clear and confident and comfortable about everything that's involved. Then we have the drafting of documents. This is actually the easiest part, provided that we've done the education, which, by the way, is a two-way street. I need to learn about you, which is part of what the online interview form does. It's part of what the consulting phase does. And if the design has also been done properly, the drafting of the legal documents is just a byproduct of that. And there are 4 key estate planning documents involved. In most cases there are 4. Sometimes there's only 3. 9.9 times out of 10 there's going to be 4, so we're going to talk about all 4. The first is a trust. The second is a will. The third is a power of attorney. And the fourth is an advance healthcare directive. So we'll talk about each of these one at a time. Next and finally, once we have the documents, there is formalities to signing them properly with a notary, with witnesses, and then there's the implementation, which is doing things like making sure that your assets are titled properly, that everything is integrated and working together in harmony so that all of this really works well, both now and later on. A living trust, otherwise known as a trust, otherwise known as a revocable trust, those are all interchangeable terms. What a living trust is, technically, it's a revocable document that creates a new relationship with a person and their property, their assets. It changes the way that you own everything that you own. You still own it, but you own it in a different and better way that addresses all of the goals that we talked about on the prior screen. Rule 1, keeps you in complete control. Rule 2, provides for you and the people that depend on you if you became incapacitated. Rule number 3, when you die, gives what you have to who you want, the way you want, privately, outside of court, with as little expense, headache, taxes as can possibly be achieved. To make it easy to understand a trust, let's just talk about a trust as being a bucket for just a moment, because we can all see that in our mind's eye. So if I told you, go ahead and picture that you're holding this bucket, or if you're married, you and your spouse are holding this bucket together, and you're going to put everything you own inside of this bucket. So if you have real estate, a home, or other property, you're going to put that inside of your bucket. Bank accounts, investments, all of your assets are going to in some way be integrated with this bucket. Okay, that's pretty easy to understand. The benefit of doing this is, well, number 1, again, you're in complete control. You can decide what to put in the bucket. If you want to take something out of the bucket and sell it or give it away or anything you want to do, you're in complete control. Nothing is being given to anyone else because while you're alive and well, you get to hold your own bucket. If you become incapacitated and unable to manage your own property and finances, someone that you trust, that we call a successor trustee, is able to take that bucket and do anything that's needed on your behalf during any period of time where you're unable to because of incapacity. And then ultimately, we're all going to kick the bucket at some point. And when we do, and we have a trust or we have a bucket, all of the assets, they don't jump out of the bucket. They're all still inside of the bucket. And the person that we trust, that successor trustee, which might be our spouse, that might be someone else that we trust later on, they're able to take that bucket and follow our instructions that we've documented as to who's supposed to get the assets in the bucket next. And the really important thing to take note of is the transfer of ownership at death of the assets in your bucket avoids probate. Contrast having a trust or having a bucket with not having one at all. If someone didn't have a trust and they just had a will or, heaven forbid, nothing at all, and they were going to rely on state law to transfer their assets at their death based on who's legally entitled to them, it requires a process called probate. Probate is a court proceeding that on a good day takes 1.5 to 2 years to fully complete. It is a public process that involves a number of public filings about everything that a person owned when they died, who's going to be receiving them, all of the creditors that they owed money to. This entire process is open for anyone who wants to see what's going on to be able to see. It comes at a tremendous expense. To just give you an idea of what that might look like, if you want to get a worst case scenario probate figure between attorney's fees, executors' commissions, filing fees, all of the necessary costs involved to complete that, again, 1.5 to 2 year long process, take everything that you own and multiply it by 5%. Take the market value. Even if you have a mortgage on your house, disregard that. Just take what it's worth plus the value of all of your other assets, multiply it by about 5%. That's the potential cost of not having a proper vehicle to transfer ownership at your death, such as a living trust. So avoiding probate is a tremendous motivator, because we don't like that cost. Whatever that number that you come up with, I pretty much guarantee you're not going to like it. And we certainly don't like the fact that all of the details about what we own, who's going to get it next, all of that is open to public viewing. There's a tremendous privacy concern there, and for very good reason. So avoiding that public default process to transfer the ownership of what we have at our death, the living trust is hands down the best vehicle to be able to accomplish that. There are 3 parties involved in a trust. The first is called a settlor, otherwise known as a grantor or a trustor. What that is, that's the person or the people that created that trust. Next, there's the trustee. Think of that as being the purse strings holder. When you create your trust, you will be the initial trustee. Or if you and your spouse create one together, you will be the initial co-trustees. You're going to be responsible for everything management-wise, just like you are right now. Later on, when you're no longer able to be the trustee, that's when your successor trustees will have the legal authority to be able to step in and act on your behalf and follow your instructions. Of course, you're able to revise in your trust documents who those successor trustees will be anytime that you want to. Lastly, the third party in the trust relationship is the beneficiary. That's the person or the people who get to use and enjoy the assets that are in the trust. So while you are alive and well, you are going to be the beneficiary of your trust. You're not giving it to anybody else yet. Nobody else gets to own it or use it yet, at least not without your permission. So during your lifetime, you are all of these 3 parties. You are the creator of the trust. You'll always be that. You are the trustee of the trust as long as you're able to. You are the beneficiary entitled to the use and enjoyment of all of your assets. Later on, due to incapacity or death, your successor trustees will step in, and your successor beneficiaries, such as children or other people that you care about, will inherit the assets in the trust at the appropriate time. We also have a will. When you have a trust, a really common question is, well, do I need a will? And you might think you don't, because a trust acts as a will substitute. But even when we have a trust, we still need a will for a few important reasons that we'll break down here. What a will is, first of all, it is a revocable, changeable document that is going to distribute any assets left in a deceased person's individual name. So if a person has a trust and most or all of their assets are integrated with their trust, they're not going to have much, if anything, left in their individual name that their will is going to direct. But if there is anything, we need that safety net. And that's why we often refer to a will, when we have a trust, as being a pour-over will. It is a safety net that basically says that you have a living trust, and if there's any significant assets left in your individual name when you die, they're supposed to go into your trust where all of your instructions are. Also, importantly, a will, if you have any minor children, that is the place where you will legally appoint or nominate who their guardian would be. And think of a guardian as being a backup parent. That's who's going to raise any minor children, live with them, make the important decisions about things like their education, their health care, all of the things that a loving parent is going to be responsible for doing. That is the role of the guardian. Of course, you're in complete control. You can always revise or replace your will with a new will that's going to change the guardians. That's always within your control, and it's very easy to do. Next, we're going to talk about a power of attorney. This is an important document that deals with incapacity. What this document does, and if you're married, both you and your spouse will have one. It's going to state that you, as the principal, appoint an agent, which can be a spouse or other people, also referred to as an attorney in fact, to act on the principal, you, to act on your behalf with respect to your property and financial matters. What does that mean? That means that you have a legally binding document that if you're not able to do something, you're still living, but because of incapacity, you can't sign your name, you can't pay a bill, you can't address something that needs to be addressed. Your agent that you name in this document has the authority to be able to stand in your shoes, act on your behalf with respect to anything that needs to be addressed. That person would be acting as a fiduciary, which is a very high-level responsibility that one human being owes to another, to only act in your best interest. Of course, you can change who your agents are or who your alternate agents are. They're almost always going to be drafted with a primary agent, which can be a spouse if you're married, and then alternate agents, individuals that if your primary agent can't act for any reason, you have one or more alternate agents who have the authority if the other primary agent is not able to act. Such an important document to have, because without it, we're back in probate court dealing with something called a conservatorship, which is where someone is asking for a judge's permission to act on behalf of an incapacitated person. It's the worst phone call that I get, and I get them probably about 3 times every month in my practice, where someone will call me up and explain a situation where someone that they're trying to help out has become incapacitated. And that's usually when they're saying, I need to get a power of attorney. And unfortunately, I have to tell them you can't, because the person's already incapacitated. They can't grant another person agency authority over their affairs when they're already incapacitated, because they don't have the capacity to legally grant that authority. So unfortunately, I have to tell that person that the only alternative is for them to go to court and get a conservatorship, which is very involved, very time consuming, very expensive. It's a court process that involves ongoing oversight. It's just a real headache, and it's super inconvenient, and there's not a lot of attorneys that want to do them because they're just inconvenient and they're not a lot of fun. So powers of attorney avoid conservatorships if someone becomes incapacitated. Can't emphasize how much stress this is going to avoid. It means the agent can sign documents on behalf of the principal. Very useful if the principal becomes incapacitated. There's two types. There's springing powers and there's immediate powers. Not to get into too much detail here, but in general, my recommendation is not to have a springing power of attorney. What a springing power is, it's where this document says that I'm granting this person authority to act on my behalf if two doctors certify under penalty of perjury that I'm not able to manage my own assets or manage my own finances. That sounds really good. It feels really good because we know nobody's going to be using that document unless we're actually incapacitated. The challenge with that versus having it be immediately effective is that when someone's trying to use the power of attorney document out in the real world, if it's springing, they have to go to the additional task of getting two doctors to prepare certifications that this person is mentally or physically unable to manage their affairs. That's really inconvenient. That can be really difficult to do, and oftentimes when someone is trying to act on another person's behalf using the power of attorney, things need to be dealt with fairly imminently. And if we are now saddled with the requirement to round up a couple of doctors to complete all of this documentation that then we have to show to a third party, such as a bank or something like that, just makes it a lot more difficult to be able to use this kind of a document out in the real world. So oftentimes the better, more practical approach is to make the power immediately effective. Definitely only name people that you implicitly trust as your agent, and if that ever changes, you want to revoke that document and create a new document with different agents that you trust implicitly, that you know would always do right by you. Lastly, we have our Advanced Healthcare Directive. This document is really important if you need medical care and you cannot communicate yourself. If you go to the hospital and you need medical care but you can speak or you can otherwise communicate, they're going to talk to you. But if you're unconscious and you can't, they need to know who they can talk to about your treatment options, because they need to be able to talk to someone who cares about you and who can advocate on your behalf. That's what this healthcare directive does. Again, we're back to the principal. That's the person who's signing this healthcare directive document, appoints an agent, a spouse or someone else. Again, we usually have one primary or more, and then we have alternates in case that primary cannot act. They are appointing an agent that's able to communicate on their behalf with regard to all of their healthcare matters. That means they'll be able to give or withhold treatment, consent, fill out forms, provide all of the support that's going to be needed, because we'd be unable to do that ourselves, and we need an agent that can act on our behalf. It also addresses important end-of-life issues, such as life support in the event of a terminal illness or some kind of an irreversible condition where death is pretty much imminent. This is otherwise known as a living will. A lot of people have pretty firm feelings about that if they were in an incurable, irreversible condition where death was imminent within a relatively short time, and continuing treatment is only going to prolong the process of dying, a lot of people they're just not comfortable with that. They would prefer in that event, if they're permanently unconscious, if they are unable to be cured, they would prefer to let nature take its course and die with dignity. This document allows you to make that same selection where you're telling your agent, hey, if I'm in this kind of a situation, after you've conferred with my doctors and it's clear that all that's going to happen is it's going to make it take longer for me to die. I would rather keep me comfortable, but let's start to let nature take its course. This removes a lot of the friction and a lot of the guilt that would otherwise come along with making that kind of a decision for somebody that we love. By the way, as we've already mentioned, this document is only needed if you can't yourself communicate or give consent. This document does not need to be used. It doesn't even come into play unless you're not able to personally communicate your own wishes. And as with anything, you can change this document. You can revoke one of these healthcare directives to create a new one with different agents anytime that you want to. Lastly, the healthcare directive is often accompanied by a HIPAA privacy waiver, just to make sure that the people that we've named as our agent in this document are able to get the information that they need about what's going on with us, so that the hospital doctors are not violating federal law by communicating with our agent. So it makes sure that the agent is able to effectively do their job. Hopefully that all helps clarify some things. Lastly, I just want to be able to conclude talking about some next steps with you. So, the most important next step to be able to really take some action and continue this journey is you want to complete our online interview form. There are two forms that we have. One is for an individual and the other is for a couple. If you are married or if you're in any kind of a relationship that is long-term, you should start by completing the couples interview in most cases. If you are unmarried or you are married but for some reason want or feel that you need to plan as an individual and not with your spouse, this is usually only the case if the spouse is perhaps incapacitated and not able to participate in the planning. Then in that event you would want to complete the individual or the single online interview. That form is going to take you step by step through all of the important components of designing your trust, power of attorney, will, healthcare directive. It's going to give you some necessary explanation and guidance and allow you to make some tentative selections that will then be able to discuss and confirm during the consulting stage of the process, which comes next. Questions consulting. It's very important to be able to have a professional to rely upon to talk through some of the items that maybe just aren't as clear and allow you to get comfortable and get clear. That's what the questions consulting stage is. That can be in the form of video conferencing, that can be in the form of phone calls, that can be in the form of email or client portal messages, whatever's necessary to be able to get you to a place where you're comfortable. That's really what the consulting phase is going to be about. Once we have a clear path on what we're going to be doing for you after completing the necessary first two steps, we're going to draft all of your legal documents that you will then review, ultimately approve. We can revise them as needed, but once you're comfortable with them, you're going to approve the documents and then you're going to sign them and you're going to celebrate the accomplishment. And people feel so good. One of my favorite things when I get to participate in the signing meeting personally, I love seeing the relief that my clients have. They truly just physically breathe a big sigh of relief for accomplishing this, because usually they've put a lot of thought into this, and there's been quite a backstory leading up to that meeting where they finally got everything in place and everything has been signed. And the next step after that is to integrate your assets. We will take care of all of your real estate for you, which is the most otherwise complex component to transfer title of. So whether you have real estate in California or out of state, we will make it very easy for you to sign the necessary documents, just changing the way you hold title from yourself as an individual to yourself as trustee of your living trust. Does not affect mortgages, does not affect property taxes. The whole purpose of doing it is so when you pass away, that real estate is not stuck in your individual name. It's part of your trust estate. You can sell the property if you want to. You can refinance it. Again, you're in complete control, but putting the real estate in the name of the trust is a really important step. We make that super easy for you. You basically just sign a document. We take care of everything else. Beyond that, we'll give you crystal clear instructions on how to integrate your other assets, things like bank accounts, life insurance, stocks. Those types of assets need to be integrated by either changing the title or changing the beneficiary to be properly integrated with your trust. Based on the type of asset and your overall situation and goals, we will give you customized advice in writing on how to address all of the assets that you have. And then it's just a matter of continuing over time to stay connected. Stay connected with your estate plan. Don't just make it a set it and forget it kind of thing. You want to review it at least every couple of years, if not annually, just to make sure everything's still relevant. Make sure that there aren't new assets that you have acquired that you need to integrate with your trust. Ask me questions that you might have about things that have come up in your life. Make this an ongoing relationship that you have with your estate plan so that it's something that really works well and for the people that you love when the time comes. That's all I wanted to share with you today. Thank you so much for spending the valuable time that you did here today. I hope that this was helpful, and I look forward to connecting with you again very soon.